I call Scott Simpson.
Thank you, Mr Speaker. It's a pleasure to rise and speak in the House as the last speaker in the third reading of this harmful digital communications bill. The bill's in the name of my colleague, the Honourable Amy Adams, but of course it was originally introduced by her predecessor, the Honourable Judith Collins, in the last Parliament. And so in the last Parliament, I had the privilege to be chairing the Justice and Electoral Select Committee, where the bill was first sent.
And you did that almost as well as your predecessor.
And almost as well as my predecessor, Tim McIndoe says, notwithstanding that he was indeed my predecessor. So, Mr Speaker, I had an opportunity as the bill was introduced to the Select Committee to hear the submissions and to take an active participatory role in the Select Committee process up until the end of the last Parliament. And so this was always going to be testing legislation in terms of where this Parliament sits vis-à-vis its responsibilities to our society in terms of new modern technology and the harms that come from cyberbullying and harassment and those sorts of things. It was always going to be legislation that was going to test the minds of MPs as to where the balance should lie in terms of our involvement in the state's role and people's right to express themselves freely using modern technology. And so, sir, I've watched with great interest as this bill has progressed its way through the House, and I've been encouraged by the quality of speeches that have been presented in this third reading, and I want to congratulate all members, even those that have, I think, used the opportunity to speak against the bill. I think they've made good points, some of them, in my view, a little misguided, but good points nonetheless. It's all very well and good, sir, in this House to oppose for the sake of opposing, and to do so sometimes on the basis of high moral ground. But actually there are times when this House needs to act and needs to do something and needs to take a lead. Often parliaments like ours around the world follow too far behind the innovations that come with modern technology. And this is, sir, a case where our parliament, like other parliaments around the world, are trying to grapple with the impacts and the negative and the downsides that occur from so much of the wonderful attributes and opportunities that new technology brings us. Jacinda Ardern, in her speech earlier on this afternoon in this debate, sir, said that Labor felt that they were wedged on this issue, that they were a little unsure about what to do and how to do it. And I think that she accurately summed up the position, because it's probably not just Labor that were wedged, it's probably all of us as parliamentarians that are wedged on this issue, because we all come into this place wanting to profoundly enhance the rights of individuals to participate in an active free democracy where freedom of choice and freedom of speech and freedom of expression are all fundamental foundation stones of that democracy. But at the same time, sir, we are balancing, as we always must, the responsibilities that go with protecting those who are vulnerable in our society and in our communities. And there are none more vulnerable and exposed to these things than in the digital age those young people who don't have the ability to use the tools that existed prior to this legislation being enacted, such as taking defamation actions and doing all the sorts of tortious legal remedies that actually do exist already in our existing legislation. Those options simply aren't practically available to them. And so this bill is a measured approach, a measured response, a balanced response to trying to juggle some of those difficult and hard issues. And, sir, I note that the Greens are struggling with it as well, that some of their members are going to vote for and some are going to vote against. So this is a bill that will test not only us as legislators but our fellow country folk as well, because they are difficult issues. And here what we are trying to do is we're trying to apply purely subjective measures to a whole range of challenging modern issues. And so with that come hard questions about about trying to find where the balance should be in terms of determining and then remedying the harm. How do we measure that harm? How do we identify it? Who decides what that harm should or shouldn't be? What are the sanctions once harm has been identified? Where does the responsibility for the intervention lie, and who is responsible for righting the wrongs? Now, this bill attempts to achieve an answer, a resolution to many of those hard questions. Is it perfect legislation? Well, it may not be perfect legislation, but it's legislation that I think is much needed in this House. And I've been heartened by comments by the Minister over recent times publicly that if we haven't got this quite right, we will look at it again. And I think that's the responsible and appropriate measure for a Parliament to take, because, sir, on this issue, there simply isn't, in my view, a do-nothing option. Our young people and their futures are too important to allow us to just abrogate our responsibility and leave it to organisations such as NetSafe or Facebook or Google or any of those other organisations to try and find their own way through it. Now, most of those organisations actually do already have their own rules, and I remember going with the Select Committee to have a look at the offices at TradeMe, where we saw how they tried to moderate the messages that were on their message boards and how they did it. But essentially it came down to a subjective values-based decision of one person sitting at a desk at a computer screen somewhere in the depths of the TradeMe organisation, making a call as to what was harmful, what was right, what was wrong, what was offensive, what wasn't. And sir, if there's one thing we know as legislatures around the world, is that offence and harm and things of that nature are a bit like beauty. They are in the eye of the beholder. So one person's freedom of speech is another person's offence and harmful bullying tactic. And sir, there's been a lot of comment on various channels, some blog sites and a whole range of other media commentaries about the infringement that apparently exists because this bill seems to somehow remove people's right to a freedom of speech. And I listened carefully to the contribution of my colleague Chris Bishop a few minutes ago, and he made mention of the Section 7 report that the Attorney General had presented when considering this bill, and in particular reference to Section 14 of the New Zealand Bill of Rights Act 1990, which of course guarantees to us all the right to a freedom of expression. However, what's really important, sir, is that that is not an absolute right. It's not an absolute right of freedom of speech, because freedom of speech does not automatically trump offences, and it does not of itself provide a protection or a way to evade the protections that are set out in other pieces of legislation. So, sir, the new proposals that are part of this harmful digital communications bill are consistent, in my view, with the Bill of Rights Act and do not impose upon the freedom of expression that is set out in Section 14 of the New Zealand Bill of Rights Act. There will be clear criteria used to determine whether someone has broken the law. For example, the new communications offence would only apply where a person sending the communication intended to cause serious emotional distress to a victim. So there is this element of intent, and where the intention cannot be proved or not shown, then the provisions of this bill obviously don't kick in. And I think that's a sensible sort of process for this bill to be considering. The communication would not apply if the communication would not cause serious emotional distress to an ordinary, reasonable person in the position of the victim. So there is a test of ordinary reasonableness. Now, our common law clearly sets out, and has done for many, many years, a test and a strong foundation stone for testing what is reasonable and what is not reasonable. And so, sir, on balance, this legislation, as I said, it's a difficult area. It's a difficult area for us all as MPs, as all parliamentarians, to get our heads around and to try and grapple with. But grapple with it we must, because As MPs, we are charged with making the hard and difficult decisions, and we cannot simply say we're not going to take a role in trying to find a solution when our young people particularly are put in harm's way by the use of modern technology. Sir, I do commend this bill to the House. It's a good piece of legislation and the Parliament has done well to consider it as it has done.
Members, the question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is called for. The clerk will conduct a party vote.
New Zealand National?
59 votes in favour.
New Zealand Labour?
32 votes in favour.
Green Party?
10 votes in favour, 4 votes against.
New Zealand First?
12 votes in favour.
Maori Party?
2 votes in favour.
ACT New Zealand?
1 vote opposed.
United Future?
1 vote in favour.
Any other votes?
Members, the ayes are 116, the noes are 5. The motion is agreed to.
Harmful Digital Communication Bill, third reading.
Call on Government Orders of the Day numbers 2 to 5.
Environmental Reporting Bill, Committee Stage. New Zealand Superannuation and Retirement Income Amendment Bill, Committee Stage. Reserves and Other Lands Disposal Bill, Committee Stage. Standards and Accreditation Bill, Committee Stage.
I declare the House in committee for further consideration of the Environmental Reporting Bill and consideration of the New Zealand Superannuation and Retirement Income Amendment Bill, the Reserves and Other Lands Disposal Bill and the Standards